The Civil Rights Act of 1964 not only prohibits private discrimination based on race, it also prohibits private discrimination on the basis of sex, making gender discrimination illegal. The story of how this happened is an interesting one. For more than a decade, Southern Democrats used the filibuster and their power on key committees to block meaningful civil rights legislation in the Senate. But in 1964, it looked like supporters of civil rights were finally going to prevail. So opponents hatched a plan. While it was clear that a majority of Congress was prepared to ban racial discrimination, opponents calculated that Congress would never support banning gender discrimination as well. In an effort to kill the bill, opponents amended it to include gender discrimination before it reached the floor. But they miscalculated. While they hoped that the amendment would kill the bill, it didn't. And so the bill banned both racial and gender discrimination when it was signed into law. Because of this history, the law left several things unclear. For example, while it bans gender discrimination, it is silent about whether this includes sexual harassment. The Supreme Court has ruled that it does, as discussed in another video. More recently, the issue of whether the Civil Rights Act's prohibition of discrimination on the basis of sex includes sexual orientation or gender identity has arisen. As of July 2022, 28 states protected gays and lesbians from discrimination, while 22 states did not. But there is no federal law that specifically does so. The Supreme Court finally confronted this issue in a pair of cases that it decided together in 2020. One case involved Gerald Bostock, a child welfare advocate for Clayton County, Georgia. His work resulted in national awards for the county, but he was fired after it discovered that he played on a gay softball team. The county fired him for conduct that it said was unbecoming of a county employee. In the second case, Amy Stevens was a man when she was hired at a funeral home, but her employer fired her after she told him that she would henceforth be presenting as a woman. The owner was a conservative Christian who admitted that he fired Stevens because he was no longer going to represent himself as a man. He wanted to dress as a woman. Both Bostock and Stevens appealed to the United States Supreme Court, claiming that this was illegal gender discrimination under the Civil Rights Act. In a surprising 6-3 decision, the conservative court ruled in their favor. The two sides had a very vigorous debate about how to interpret the words, on the basis of sex. The dissent accused the majority of literally changing the meaning of the law. In his dissenting opinion, Justice Samuel Alito said that when the law was passed in 1964, discrimination because of sex was not understood as having anything to do with discrimination because of sexual orientation or transgender status. Any such notion would have clashed in spectacular fashion with the societal norms of the day. The plain truth is that in 1964 homosexuality was thought to be a mental disorder, and homosexual conduct was regarded as morally culpable and worthy of punishment. Americans in 1964 would have been shocked to learn that Congress had enacted a law prohibiting sexual orientation discrimination. According to the dissenters, Congress had the power at any time to update the Civil Rights Act to include LGTBQ discrimination, and it is the job of Congress, not the Supreme Court, to change the meaning of the law. Justice Brett Kavanaugh wrote, "To prohibit age discrimination and disability discrimination, this court did not unilaterally rewrite or update the law. Rather, Congress and the President enacted new legislation, as prescribed by the Constitution's separation of powers. Judges may not update the law merely because they think that Congress does not have the votes or the fortitude." The majority disagreed that it was changing the meaning of the law at all. It admitted that those who adopted the Civil Rights Act might not have anticipated their work would lead to this particular result. But the limits of the drafters' imagination supply no reason to ignore the law's demands. The majority argument was fairly simple and straightforward. It said that discrimination against LGTBQ individuals is literally discrimination on the basis of sex. Justice Neil Gorsuch wrote, "An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questioned in members of a different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids." The court gave an example. If an employer fires a man because he is dating a man, but does not fire a woman because she is dating a man, the key difference is the sex of the two employees. This is discrimination based on gender. So since 2020, LGTBQ individuals have been able to sue their employers for discrimination in federal court. However, the decision was limited to Title VII, which relates to employment discrimination. It did not involve Title IX, which covers education. One emerging question is whether Title IX requires intercollegiate athletics to permit transgender athletes, such as swimmer Leah Thomas, to compete in women's sports. The Supreme Court has yet to weigh in.